A few weeks ago, we discussed Indianapolis versus Edmond, a Supreme Court case that held drug checkpoints to be unconstitutional because they lack individualized suspicion that a particular driver committed a crime, and they're designed for general crime control purposes. So those are unconstitutional. A few weeks later, we discussed the case Neff, where law enforcement were trying to get around the rule by setting up ruse or fake checkpoints, meaning they would put up the signs saying there's a checkpoint ahead when in fact there wasn't one, and they were trying to see how many drivers would take the next exit off the freeway, and then they would pull over those that would take the exit. Now, if you're interested in that video, I will link it below because it gained a lot of traction. Thousands of people watched it. It is a very interesting case, so go ahead and watch it. And today, keeping with the theme of checkpoints, we're going to discuss whether the Fourth Amendment permits law enforcement to set up a checkpoint to ask general questions from the drivers. Welcome to LAWSTACHE channel. If you're new here, hit that subscribe button. If you're a returning viewer, thanks so much for watching my channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a Supreme Court case, Illinois versus Lidster, and it deals with what we can call informational checkpoints. But first, let me give you some factual background. A week prior to the checkpoint, there was an accident where unidentified motorist hit and killed a 70-year-old bicyclist. Now, the officers set up a checkpoint on the same highway a week later, and they would stop every single motorist for about 10 to 15 seconds. They would ask the driver if they saw anything the week prior, and they would hand out a pamphlet, again seeking more information about the accident. Mr. Lidster was approaching the checkpoint. He swerved, almost hitting one of the officers. When he arrived and finally stopped at the checkpoint, the officers could smell alcohol on his breath. They conducted a field sobriety test, arrested him for a DUI, but now Mr. Lidster challenges the validity of the checkpoint in general, saying that it violates the Fourth Amendment, which protects him and all of us against unreasonable searches and seizures. Now, we know in Indianapolis versus Edmond, the case I've previously discussed on this channel, that drug checkpoints are unconstitutional because they lack individualized suspicion that that particular motorist is committing a crime. So here, Mr. Lidster is making a similar argument. He says there is no individualized suspicion that he or anybody else in the line in this checkpoint was committing a crime. And so he says this is a general crime control type of checkpoint, and it should be unconstitutional. But the Supreme Court says that this checkpoint is different from Edmond, and here's why.
Everybody agrees there was no individualized suspicion here. But Edmond concerned the kind of stop to which reasonable suspicion might be relevant, where it could matter, namely a stop designed to see whether a car's occupants had committed a crime or were committing a crime. And this is not that kind of a stop. It's a very different stop with a very different kind of purpose. The stop is one of enlisting the help of a vehicle's occupants as members of the public in providing information about a crime committed not by them but about other people. So Edmonds, we think, is beside the point.
Now that Edmond is out of the way, the Supreme Court tells us that some checkpoints are justified even without individualized suspicion. They say this is because the Fourth Amendment treats your vehicles not like your castle. Why are they using this language, using the word castle? Well, because your home under the Fourth Amendment gets the most protection. It is explicitly listed in the Fourth Amendment. But your vehicles do not get that protection. In fact, this shouldn't surprise you. If you've been paying attention to my channel, we've discussed many cases involving vehicles. And you know, there's tons of exceptions when it comes to the Fourth Amendment and your vehicle. If you're interested in those exceptions, I urge you to watch one of my series called Vehicular Searches Without a Warrant, where in 5 short videos, I discuss all the exceptions dealing with vehicular stops and the searches that follow. So watch that series after this video. Now, the court also says that when we're dealing with informational checkpoints, these are not designed where we have individualized suspicion. In fact, the court says that these checkpoints are not made to be intrusive and they shouldn't provoke anxiety. The court also says that this is an important law enforcement tool. They have to be able to rely on general public to gather information. And there's nothing unconstitutional for law enforcement to approach a pedestrian and ask questions. And of course, it has to be a voluntary conversation. Well, for whatever reason, the Supreme Court says that this is also a voluntary conversation between a motorist and law enforcement. So the court says that this is constitutional. Here's what they say.
So our conclusion on the law is that we apply a rule of reason to such stops. To determine whether a particular stop was reasonable, we have to look to the gravity of the public concern, the degree to which the seizure advances the public interest, and the severity of the interference with individual liberty.
Now, applying this test, the Supreme Court tells us that there was a grave public concern. Police were investigating an accident involving a loss of human life. The stop was tailored to address that grave public concern. And they also said that the stop lasted only a few seconds. A pamphlet was given to the motorist, and so there was minimal intrusion on liberty interests of the individual. So here it is. Informational checkpoints are constitutional under the Fourth Amendment, says the Supreme Court. But do you agree? Leave your thoughts in the comments below. I'm very interested. Do you think the Supreme Court got it right in this particular case? I will say there is a difference between a pedestrian and a motorist. A pedestrian might avoid law enforcement altogether by crossing the street or walking away from them.
What?
Hey, Matt?
Huh?
Matt?
Your words are just sound, sir.
Matt, don't listen to a word I say and keep updating your fantasy team.
Continuing to ignore you, sir.
And Matt, don't listen to a word I say. Continue updating your fantasy team.
What?
Matt?
What?
Ignore me and keep updating your fantasy team.
Ignoring,
But when you're in the vehicle, even though the Supreme Court says that this is a voluntary interaction, I say it might be more difficult for a motorist to avoid a checkpoint, and it would raise all sorts of red flags if an individual tries to go through the checkpoint without stopping or try to avoid it altogether. The Supreme Court also didn't address the constitutional right to interstate travel. What do you think? We have a right to interstate travel. Does this case essentially goes against that right? So give me your thoughts. Thank you again for watching my channel. If you enjoyed this video, give it a thumbs up. Please subscribe to LAWSTACHE channel. If you're listening to the LAWSTACHE channel on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, stickers, and other items. Thanks for watching.